Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Morning, everybody. Welcome to one of two sessions of the Appeals Court going on today on Friday, October 3rd, 2025. We are in courtroom 3 over here, the Armstrong courtroom. I'm sure you've all checked in, so you're in the right courtroom. I see experienced lawyers right in front of me and some in the audience. So as for those who haven't been here before, it's 15 minutes per side. There's no rebuttal. You're free to use your entire 15 minutes, but there's no obligation to use the entire 15 minutes. If you feel you've said everything you need to say, you can sit down with no penalty. We'll be hearing three criminal cases and 3 civil cases. We'll probably take a break after the 3rd or 4th case. And I'd like to welcome the students and teacher from Framingham State, or you've got an audience of students watching you, so be on your best. Also, we have the materials from all the cases are here on our tablets, so if you see us looking at our tablets, it's not that we're looking at the postmortem of the Red Sox, we're actually looking at case materials. So I think that's all. Oh yes, I forgot to introduce the panel, which is Justice Sachs, Justice Allen, I'm Greg Massing. And so we'll call the first case, which is Commonwealth versus Ramon Rodriguez, 24 P 1476. Morning, Mr. Benyon.
Good morning. To the presiding justice, may it please the court. We seek reversal of the Commonwealth of this case based on the Commonwealth's proof. Even viewed in the light most favorable to the government, it fails the constitutional sufficiency standard. And this court should think about remanding in light of the due process concerns that are raised in the brief. Now, under Jackson versus Virginia and Lattimore, the question is whether any rational fact finder could find each element beyond a reasonable doubt when the evidence, even viewed in light most favorable to the government, but here's the important part, without the piling of inference upon inference. And that's the problem. As I raise in the brief, there are some red flags in this case that should unsettle you. In this case, we only have a single witness to the event. It's AR's decades-old childhood memory. It's brief. It's uncorroborated. This occurred in a third-party residence. Neither person from that residence was called to testify.
Some of these issues were already settled in the Santos case, weren't they, where our court said that the testimony of the victim alone is sufficient to uphold a conviction for indecent assault and battery? And
I cited that case in my brief.
Yeah, you did. So how is this different?
So again, you can look at, for example, General Laws Chapter 277, 63, says that anything after 27 years, any indictment must have corroborating evidence. That's fine. But what we're looking at is due process. And you know how the system works, so I can talk to you about it. When we have a disagreement as to facts, what our system does is we put 12 people in a jury box, we swear them to an oath, and then we let them decide, presenting the evidence. And whatever really occurred, we're more concerned with what happened with, or we're more concerned with what the jury finds. And in this case, the only saving factor for bad memory, or in the best case scenario, in the worst case scenario, an outright liar, the only case that helps the defendant in a criminal case in this country is the high standard of proof. And that's what we're asking you to look at, beyond a reasonable doubt, without piling of inferences. In this case...
So here we had, of course, a bench trial to a judge rather than 12 jurors.
That's true.
And the standard is whether any rational fact finder could find each element of the offense beyond a reasonable doubt.
Beyond a reasonable doubt.
Right. So are you saying that the judge did not properly apply that standard beyond a reasonable doubt? What is the legal error that you contend the judge made?
The error is that the standard was not meant beyond a reasonable doubt. And
So the judge acted irrationally in crediting the victim's testimony?
the trouble here is...
That's what we have to find, right? I mean, I understand you have a difference of opinion with the judge on what the facts were, but we're here only to review whether the judge made some error of law. That's all we can correct.
Yes, but you'd agree with me that if the proof doesn't meet the high standard, that's a legal error, and it is. And the trouble with these cases is that even a judge, and certainly a lay jury, can be swayed by the facts of these types of cases. And that's the problem, is that you always need to watch it out from a jury, and even an experienced judge, from not looking at beyond a reasonable doubt, but not wanting to let somebody who committed such a crime go free. The standard has to be high, otherwise the system can try and convict people who didn't commit the crime. Even the judges, or excuse me, even the Commonwealth's expert said that people aren't human lie detectors, and there's ample evidence of witnesses not remembering cases specifically or lying, especially in cases of sexual abuse of a minor, and that's the problem here. One of the red flags that I pointed out is that the AR's testimony was not believed initially by her own mother. That is a problem when you're looking at credibility. Also, I think...
When you say we're looking at credibility, we aren't looking at credibility because we can't watch the witnesses testify.
That's true.
It was the judge who watched the witnesses testify. He saw the victim testify, he saw the defendant testify, and how can we second guess his determination of who to believe? We can't see whether the witnesses were stammering and hesitant and, looking away when they were testifying. We can't see their demeanor. We can't hear their tone of voice. So how can we second guess what the judge concluded after seeing all that and taking it into account?
So I'm not asking you to rejudge the credibility of the witness, but what I am asking you to do is take a look at these points that came in evidence at trial to make a determination as to due process proof beyond a reasonable doubt. And that is one point that you can look at, is that the mother didn't believe the child's testimony when she disclosed it immediately after. Then you have a long pause. It doesn't occur until like 5 years later that this is coming forward in law enforcement. And as trial counsel pointed out, by that time you have a contentious court battle, separation, and a fight over child support. And so that's where...
So are you suggesting that in any case where a victim of sexual assault or an asserted victim of sexual assault isn't initially believed by her mother, that testimony can't rise to the level of proof beyond a reasonable doubt?
So I'm going to decline to let you put those words in my mouth, but what I did ask you to do...
Well, tell us what rule of law you're looking for that separates victim testimony that can be credited versus testimony that can't be credited, or that can or can't rise to the level of proof beyond a reasonable doubt.
So again, it's the point here is that and I cite the statement, and a lot of people look at it as just an old cliche of the law, better that 10 guilty men go free than one innocent man go to prison. But that is not just a cliche. It's designed to impress upon not only members of the public, but also the court and bar, the importance of that standard. Again, at worst, a witness can come in and not remember correctly the events of a decade previously. At worst, the person could lie. And if believed by the jury, that is a problem.
Right. So what is the rule that you want us to adopt?
Well, your job is to review the case for proof beyond a reasonable doubt.
And so what rule would suggest that? Sorry.
I'm sorry, but don't we have to do that in the light most favorable to the Commonwealth? You're asking us to look at it in the light most favorable to your client.
No, I'm asking you to look at the evidence as it was presented at trial and judge that by whether this is proof beyond a reasonable doubt. And that is a...
But in the light most favorable to the
In the light most favorable,
right?
I said that at the very beginning of my remarks. I understand the standard. I do.
So in terms of like that her mother didn't believe her.
It's a data point.
You could, there's lots of reasons why a mother might not believe that a child's being assaulted by somebody who she had a relationship with, and she might, but is that?
It's a data point. The fact that the mother didn't believe her, it's a data point. Another data point, the fact that when this does come out and the young girl speaks to the police, there is a fight over child support and contentious court cases going. That's another data point. And you look at these points to make a determination as to whether this defendant received a fair trial. The problem is that based on the young girl's testimony alone, even if believed by a fact finder, the trouble here is that it might not be proof beyond a reasonable doubt looking at all of the evidence that came in at trial, and that's the problem here. Again,
Can I ask you about something that we haven't got there yet? Your third claim has to do with the delay, and is that another data point that you want us to consider in terms of sufficiency, or are you saying that there was some sort of that the case should have been dismissed because of pre-indictment delay?
no, it's a data point that you look at when you're judging proof beyond a reasonable doubt, and I want you to think about that, because the event is described is just a mundane event that takes place at this third-party resident, Julia's apartment. And when the events are spoken to by the police, so many years have passed by that it's difficult to even remember what happens. And so when you have these significant delays, it really puts pressure on the defendant to try to come up with physical evidence that might not be there, to come up with witnesses who might corroborate his story, but memories might be forgotten, or memories might have faded.
Doesn't all those things inure to the defendant's benefit? It's the Commonwealth that has to put on the proof. It's the Commonwealth that has to come with evidence.
Can I disagree with that? If you have a young girl who at worst might have been manipulated to testify, then no, because you have a young woman who's testifying who seems to convey that this occurred. But no, that puts the defendant in, remember, that's how the government gets the indictment, is they have this witness, and then it puts the defendant in a position where he then has to try to recreate events that occurred years before, ask about memories that, or events that, where memories might have faded, evidence might have been destroyed, and that's the problem.
It's certainly true that the passage of time can lead to the loss of evidence fading, memories, lost physical evidence.
Yes.
Is there any specific evidence that you say was lost to the defendant here because of the passage of time?
So neither Julia nor the daughter were called to testify, and that's a problem. Memories, again.
Couldn't he have called them?
He could have, but again.
So how is that evidence lost to the defendant because of the passage of time?
In that case, it might not have been, but for example, evidence of the defendant even being in the room could have been lost.
Well, could have been, but is there any specific claim here that it was? Is there any reason to think that there was particular evidence lost here?
Again, we're looking at one data point that shows that it puts a defendant in a precarious position to have to try to make, because once the government makes the claim, the defendant then does, he's not required to, but if you can find evidence that proves that you didn't commit the offense, that's just better for everybody. It's better for the truth. And in this case, we don't have that. That's one of the problems with the delay. And that is another data point that you look at when you're looking at proof or assessing proof beyond a reasonable doubt. I think that hits every point that I made in my brief. I know that you've read the materials and the record. If there are no other questions, then I will rest on the brief.
Seeing none, thank you. We'll hear from the Commonwealth.
Good morning, Your Honors. May it please the Court. Elizabeth Simonian for the Commonwealth. Looking at the defendant's sufficiency claim in this case, the case begins and ends with the proposition that Commonwealth v. Santos stands for. That being, a victim's testimony standing alone is legally sufficient to convict the defendant of indecent assault and battery on a child under 14 beyond a reasonable doubt. So long as the victim testifies to the facts which constitute each element of the charged offense, that is sufficient. Now, we see that the legislature pondered the idea of corroborating evidence in a case like this. As my brother pointed out, GLC 277, Section 63, the legislature stated that after 27 years, corroborating evidence would be required, aside from the victim's allegations and testimony. So we know that the legislature thought of that, and they didn't put it in the statute, and as Santos says, we don't need that corroborating evidence. Here, the victim testified to all those facts which constitute every element of the charged offense. That was sufficient. And although the Commonwealth was not required to produce additional evidence, they did. They produced the mother, and they also produced a research psychologist as well to prove their case. So although my brother says that the delay, kind of moving forward, the delay here should be looked as a data point, I would argue that these constitutional claims have no place in the sufficiency argument. They are waived. They were not raised pre-trial. They were not raised at trial. It might be the position it should be seen as a data point. The Commonwealth believes they should not be considered. As for the credibility arguments,
We have to look at whether, even if they were waived, don't we have to look at whether some error in that regard created a substantial risk of miscarriage of justice?
but here when we're taking the evidence in the light most favorable to the Commonwealth, that is not to be considered, because we're looking at the evidence that was produced at the trial, and at that time the Commonwealth presented evidence which proved this charge, that single count here. As for the other claims, the fabrication claim and the child support claim, as your honors pointed out, those are theories that the trial judge, as the fact finder, considered, and he implicitly credited the Commonwealth's witnesses by finding the defendant guilty in this case. There was also a point made that neither Julia or Julia's daughter was called in this case. As Your Honor Sack said, the defendant could have called them. The Commonwealth, although it was pointed out by defense counsel at the trial level, possibly a missing witness instruction, that's not needed here. We don't need to present those additional witnesses when we already presented evidence to prove that single count. So with that, if there are no further questions on this case, I would respectfully request that this court affirm the defendant's conviction on that single count.
Seeing none? Okay.
Thank you.
Thank you very much. Thank you both. The case is submitted. Okay, the second case that we have today is Commonwealth versus Frederick Austin Jackson Jr., 24P1322.
May it please the court, my name is Charles McGinty. I represent Frederick Jackson in this interlocutory appeal from the denial of a motion to suppress. I suggest that we're guided here by the language of Florida versus Royer. In the name of investigating a person who is no more than suspected of criminal activity, the police may not carry out a full search of the person or of his effects. Yet, that's precisely what happened here. Police, following a report of a threat made by a man with an outline of a gun in his pocket, stopped Mr. Jackson. They frisked him vigorously. No gun was found. The officers immediately recognized him. They knew that he lived on the steps of a church up the street on Newbury Street. They knew where he came from. They said, "You're a necker," meaning that he had come from the Hose Neck section of Quincy. His eye was injured. It was obvious that he could barely see. He was homeless, he was drinking, he was plainly an alcoholic.
Attorney Madigan, I'm sorry to interrupt you, but we've read the record, we watched the video. I want to ask you, you're not contesting that the police had reasonable suspicion at the beginning.
Correct.
To stop him.
Precisely right.
And conduct an initial pat frisk?
Not contesting.
Okay, so so when did it turn from, when did it, and if you could give us like a time on the video especially, when did it turn from a legitimate Terry stop to something else?
Which is exactly what I want to address. The officers knew him at the moment that they stopped him. They even knew him at the moment they frisked him. They recognized him. They knew where he came from. They knew everything about him. And his physical appearance was of a man impaired. So at that point, there's no hint that the officers feared him or feared that he might do something to obstruct their investigation. So whence the articulable facts to continue with a frisk?
Well, they may know who he is, but they don't know that he doesn't have a weapon. So are you challenging the initial pat frisk?
No, I'm not challenging the initial pat frisk.
So at what point, what timestamp in either video do you contend the pat frisk ends and the search, unlawful search begins?
I contend at 1323 is the moment when they begin to put their hands into his pockets of his jacket. But before that, the moment when they moved toward his jacket and ultimately toward his luggage and ultimately toward his person, they had no reasonable suspicion that he posed a risk to them. The threshold here for the pat frisk under Terry is that the police have to have a reasonable basis to apprehend danger from the person who's there. And the person who was in front of them was a person they knew his history, they knew where he was from. They didn't have at that point any reason, any articulable reason to advance and examine further any of his belongings. Moreover, the SJC has left open the question of whether or not police can examine the person's belongings when they are on the street and the person is surrounded by police and is otherwise those materials are otherwise unavailable to them. That's Commonwealth versus Pagan, or Commonwealth versus Pagan. And in that case, the Supreme Court, the SJC, did not establish the right to extend a frisk to personal belongings that are nearby, and raised as the concern, what if there were multiple police officers there? What if it was segregated from the person so that he wouldn't get immediate access to that? So I would suggest, Your Honor, that A, Pagan left undecided whether or not you could touch the separate belongings, and B, there was no reasonable suspicion at that point to advance toward his jacket and do anything there. And then pointing out the time here, reach into his jacket by 1323. Minnesota versus Dickerson. You could pat frisk, but you can't feel and you can't reach in. I submitted in the brief a photograph showing they did exactly that. Their hands were going into pockets too small to possibly reach or to include a firearm. So, and as you watch the video, it's apparent they're not frisking, they're searching. They're going into pockets in the jacket, removing items from the jacket. Where under Minnesota versus Dickerson is the authorization not to pat frisk for a weapon? And if it's a firearm, it would have some mass, but to reach in and remove articles.
So let's say we agree with you that there was an unlawful search here, but what was incriminating, and that might entitle you to suppress the immediate fruits of the search. I'm not aware that anything was found in the search, if we call it that, that was incriminating. But what you're really seeking to suppress, I think, are the statements. So how did the statements result from the search so as to be the so-called fruits of the poisonous tree?
So the exclusionary rule provides that evidence obtained during an unlawful stop or seizure cannot constitute proof against the victim or against the person of the search. Wan Sung,
obtained during?
That are obtained during and using that against the victim of the search.
Okay.
We look to,
So the fact that the statements were made during the search is enough per se to suppress the statements?
and how do we know that? We know it from Wang Sung. We know it from other Supreme Court cases, Brown versus Illinois. We know, and just go down here, Wang Sung and Brown versus Illinois make clear that there is no logical distinction between physical and verbal evidence. Quote, nor do the policies underlying the exclusionary rule invite any logical distinction between physical and verbal evidence. The wrong here consisted of the police having control of the defendant's person at the time that he made the challenged statements. That's New York versus Harris. Indeed, so broad is that protection under Article 14 and under the Fourth Amendment that relief under the Fourth Amendment and Article 14 extend to all manner of evidence that's developed during a unlawful intrusion on the person of another.
So it's enough that the search, what you contend is a search, and the statements, the questions by the police and the statements by the defendant coincided in time? There doesn't have to be any more causal relationship than
No, the government's responsibility is to prove that there is no connection between the two. And if you notice, in a footnote, the government gives up an argument of attenuation. Attenuation would be that there's some kind of causal break between the intrusion and the statements. And here, the Commonwealth withdraws any claim that there was attenuation, in effect, by not claiming that there's separation between the illegal police conduct and the evidence. The Commonwealth's effectively conceding the linkage between the statements and the wrong. Those are the very predicates of the contention that we're raising here on behalf of Mr. Jackson.
And so you also raise a custody Miranda issue.
Yes.
The way if I understand your argument on the fruits of the poisonous tree, we don't even need to get there. If we agree with you that after the initial pat frisk it went too far, then we don't even have to consider whether he's in custody or not.
Well, under the Fourth Amendment, a search alone is protected. That's true under cases both under the Fourth Amendment and also under Article 14. So either a search or a seizure suffice to implicate the protection under the amendment. And here, without any proof of seizure, the unlawful search alone, freed of any claim of attenuation, that mere fact of search suffices to warrant the application of the exclusionary rule. With respect to a search, the SJC has indicated that if we look to Article 14, that it provides more substantive protection than does the Fourth Amendment. Under Article 14, a person is seized by a police officer if, in view of all the circumstances surrounding the incident, a reasonable person would believe that he was not free to leave. This is a broad protection here that the Supreme Court has interpreted broadly. It includes such things as stopping a person without justification, suppression. It involves taking his shoes off, suppression. It involves chasing a person who the police want to stop but have no grounds to do so, suppression. Here, you have in effect, an a fortiori situation. You have a homeless alcoholic with the police poking through his goods and standing him up to turn him around to go through his pockets. During that time, the fruit of that continued custody of Mr. Jackson were his statements. It doesn't have to be contraband. It includes statements. And that goes back, Juan Song makes it pointedly clear. It's black letter law. So with the seizure comes the suppression of the statements. And the statements, since you asked about the sequence.
There's one very early on, he says, I was down by Italy.
Yes.
That seems to be, that's the worst
Well,
thing in there.
he doesn't say that he was down by Italy. They ask him, were you down by Italy? And he says, I don't remember. So he doesn't say that he was down there. The statement that was what they were looking for was the statement about whether he had a verbal confrontation with the person at Italy, because that's what placed him at the scene, is that. And that's what they were looking for. I mean, why were they pressing him for to threaten someone? Presumably because they wanted an admission that he was the person that was down by Italy. So that came considerably later. So at the very beginning of the examination of the jacket, the images aren't terribly clear until you get to 1323. They're reaching into the jacket 1323, and they're pulling out what appear to be earbuds. I don't know, it's some kind of wire.
They get a blue surgical mask.
Right. And I mean, it's pitiful. This is a homeless man. He's got these modest goods inside his jacket, inside his luggage. There's no license to take advantage of him in the fashion that was done. So
Can I just
here,
ask, are there any statements that he made that you're not looking to exclude? Because I'm still confused about the timing.
Okay, so-
of when, because from my review of one of the body, I think it's clip A, they began to frisk him and they were still patting his jacket when he started to say, spontaneously, I don't carry guns, I don't threaten anybody. He made spontaneous statements regarding a firearm before any inquiry about it.
Respectfully-
So are those statements, when they're still on the exterior of his clothing, what do you say to those?
First, they asked him, did you threaten anybody?
Yes.
That's before his responses. The reaching inside the jacket, as I say, is at 1323. The I don't carry guns is 1332, about 9 seconds later. It's after. People ad lib was at 1338, again, after. They complete the search of the luggage, by the way, spreading it out, opening it up, removing things. You could see them taking things out.
I think you're at the end of the time. Let's just address the statements.
I'm sorry?
If you could just address the statements. I think that's the question, is what were the statements and when did they occur?
And the statements were, I don't carry guns, people ad lib, and the final statement was the one of principal focus, which was 2 minutes after, at 14:20, they're removing items from his rear pants pocket. At 16:12, the officers ask a question, did you get into some sort of argument with anybody? In response to interrogation there, because that's obviously, I may have had a verbal confrontation, but I didn't get physical because I can't even see. That was the statement that they sought. It put him at the scene. The question and the response was after.
That one is 1612?
1612, yes.
Okay. So your time is up, I think.
Oh, I'm so sorry.
Unless there's any other questions, I think we understand the argument, and we'll hear from the Commonwealth.
And I would simply ask that the court reverse the order of the court below, which it denied the motion to suppress. Thank you.
Thank you. Mr. McGinnett, you can stay at table.
Oh, sorry.
Good morning, Your Honors. May it please the Court. Paul Lynn for the Commonwealth. In this case, Officer Croak testified at the suppression hearing that he was told that someone had just threatened to shoot the customers and the staff at Italy. That is the beginning of this case. That is what happens around 8 o'clock that evening. The defendant is described, or the suspect, I should say, is described.
Is that a he doesn't challenge the initial stop. Is that an anonymous tip?
That does not come out at the suppression hearing. We know from the record of the case that it's the assistant manager at Italy who makes the 911 call. So yes, he's got this information. She testifies.
So he doesn't contest that that it was correct to stop him. What he does contest is that after they find him, he's a completely harmless guy that they know, and they pat frisk him. He's not got a weapon on him. That should have been the end of it.
Well, what the problem is, of course, that he threatened to kill people.
Is that in the record of the suppression hearing?
Yes.
Well, let me ask you what I'm really getting at. Your brief contains a recitation of evidence from the trial that already occurred.
Correct.
In this case. This is a motion to suppress filed after a motion for new trial. Why is the evidence at trial even relevant to our issue today?
Just to explain how we got here.
Well, it's not how we got here, because that evidence was developed after the events surrounding the motion to suppress. So I don't understand how it's relevant, and it seems to me it's perhaps aimed at coloring the case against the defendant, and I wonder if it's fair.
It's not fair to decide the case based on prejudice against the defendant, but it is relevant to, again, what the facts were, what happened here.
Well, your brief is offering more evidence from the trial that occurred, and he got an order for a new trial, so don't we just disregard what occurred at the first trial?
You may.
Why should we consider evidence at trial that suggests he committed this offense in order to decide whether the evidence should have been allowed in at trial?
You shouldn't. It's just simply background information.
Okay.
The facts are, the facts that are relevant here is that Officer Croak gets information, and he testifies to this.
Right. So I can't speak for the rest of the panel, but to me, that sort of background is not helpful because it's not relevant, and it suggests an attempt to color the defendant's legal argument by saying, well, he's guilty anyway, so why should it matter? And I don't find that helpful, just for future reference.
I will keep that in mind, Your Honor, but that certainly was not my intent.
So the testimony at the suppression hearing is there was a call for a person with a gun. Is there anything in the motion to suppress about threatening people?
There is at the suppression hearing. I will find the exact page here. Pardon me.
And I know there's outline of a gun as we hear in the
There we go.
in the video.
Yeah, it's motion transcript 9 through 11. The officer says that he received a word that the person had a gun who had threatened to shoot the customers and staff.
Okay. It's on page 11, or page 11, record. All right. Yes. The dispatcher may have said that it was a call from Italy, patio area, and that a person had threatened to shoot the customers. Okay.
Yes.
So they stop him again, and they know him, and he's partly blind. He's ambling along. He's not. If they search him, he's not armed.
Right.
So how do you address Florida v. Royer that a Terry stop doesn't justify this full-blown search?
It doesn't, but a threat of violence. Now, you can say, oh, this is a harmless guy, but he's not harmless. He has threatened to kill people.
Well, armed and dangerous, right?
Yes.
Is he armed and dangerous?
Well, no, after the search, they determined, no, he is not armed and dangerous.
Isn't
but
it
they
pretty
have-
sure, I mean, they're not really afraid of him when they get there.
They are not shaking in their boots.
No,
They're
they're
treating him gently. They're like, okay, we know who you are, but we got to investigate this. And that's, Commonwealth versus Manha, which I cite in my brief. The court says, although ordinarily a Terry stop is limited to a quick, gentle frisk, there are times when more than that is needed to dispel the threat that has been created. And here you have...
And isn't MANA about, like, whether you have to pat frisk a backpack or not?
Yes, exactly.
In an automobile?
In an automobile, no question. It's not...
Right, so there's an exception for searching or pat frisking items in automobiles that doesn't necessarily extend to encounters on the street.
The question of whether a search is proportional, or a search is proportional to a Terry stop, is whether or not the police have reason to believe that the defendant is armed and dangerous. Here, the defendant, they have heard that the defendant has said that he is armed and dangerous. They do not have to assume that
let's suppose that a defendant has a safe in which you ordinarily keep money or other valuable items, and it's on wheels, and he's wheeling it along the street, and it's got a combination lock on it, and the police have reason to think that there's a gun in that safe. Can they open up the safe? Let's assume that one of them's an expert safe cracker. Can they open up the safe to see if there's a gun in there, or is the Terry stop limited to determining whether he has a weapon on him that he can use to threaten the officers or harm them while they have stopped him to make this preliminary inquiry?
The latter, but I think that's a bizarre situation. I can't imagine how opening
but
a
this
safe.
was
It was a hypothetical.
Yes, it was a hypothetical, but this is a suitcase. And
Right.
they're not just feeling about the outside of the suitcase or checking the outside pockets. They open it up and go through everything in the suitcase.
Right, and you can see in the videos that it is a hard suitcase. It doesn't have anything they can feel from the outside. And in Manha, they say, if you can't figure out from the outside whether or not it contains a gun, and you have reasonable suspicion that the defendant has threatened someone with a gun, then you can open the suitcase.
Are we concerned with officer safety here, or are we concerned with investigating a crime?
Officer safety. I mean, it's the safety of the officer and the public, and no longer the at Italy. He's beyond that now.
So then don't we exactly get into the question left open in Pagan, whether whether the police controlled the situation and the defendant couldn't possibly reach for the gun in his suitcase?
Sorry, I didn't hear the last.
So if it's about officer safety, don't we get to the question left open in Pagan? That Pagan said, we weren't sure that the officers had control of the situation here. But in this case, it's pretty clear the officers have control of the situation. They're not he's not going to go into his suitcase, get out a gun, and threaten the officers. There's no way that's going to happen.
No, but he has just threatened to shoot.
But we're talking. You just said we're
restaurant.
concerned about officer safety, not about investigating a crime.
No, but
He's not armed. There's a suitcase over here. He's going to, with 6 officers around him or 3 officers around him, he's going to go get into his... Seriously?
Seriously, Your Honor.
Okay.
I think that's, I
understand your argument.
Yes. No, and I think also he was excuse me a second. The report on the radio, the broadcast, said that he was wearing the denim jacket. So when they come across him, they have definitely, these denim jacket is at this point draped over the handle of the suitcase. They are certainly within their grounds to search because that's what he...
Shouldn't they pat frisk the jacket?
They do. They do.
I mean, before going into the pockets, they should probably pat frisk to see if
you can see that they do. They pat it and then they bring stuff out. And that goes on, well into the 13-minute range when he says.
Can I ask you about the motion judge said, I've seen guns that fit into wallets, and he finds that the police looked into what appeared to be a wallet, which could have held a small gun. You say that's clearly erroneous.
Clearly erroneous.
How much of the judge's findings are not clearly erroneous?
All the rest of them. I mean, the other thing is that he doesn't have a wallet on him. That's clear from the video. What they have is what the judge called a wallet. You can see in the video is an item with a reflective screen, which is almost certainly a cell phone, which has things on top of it. It's not a wallet. I think turning to the statements, because the defendant was wearing the jacket at the time of the time he made the threats, the police have.
Is that from the trial, or is that from?
That's from the description of the defendant, the description of the suspect that's given by the officers
At the motion to suppress?
at the motion to suppress. Says he's wearing a denim jacket. So the police do have a right, to, at the very least, even if they don't have a right to search the suitcase, they have a right to pat frisk the jacket. And it's not until well after 1335 that they start going through the pockets of the jacket. And of course, the jacket, the pockets, I disagree with my brother. You can see the pockets are big enough to hold a gun. So these statements he makes, and first of all, the statements he makes are not particularly incriminating at that point. He says, I don't carry weapons. People ad lib. The only statement, as my brother points out, that's even remotely incriminating is when he admits that he went to Italy.
Well, I mean, it doesn't matter if it's incriminating or not, right? He could suppress exculpatory, inculpatory. And you say that none of it is suppressed. There's no moment when the search exceeds the permissible, so there's none of it.
No, the Commonwealth's position is there is no moment. But if the court does find that the search of the suitcase was unlawful, the only statement that would be suppressed from that would be the statement later on where he admits he was at Italy. And I think it's clear that he's never, if you look at the footage, he's never in custody in the sense of Miranda. He is always standing on it, except for that 1 minute where they're frisking him. First, they frisk him, they pat frisk him when they arrive, and then they go through his pockets. The whole rest of the stop, he is on his own. He's standing around, he's talking to the officers, he is not in a police car, he is not handcuffed, and he's let go within 10 minutes and free to go. They don't stop him. So he is never in custody for Miranda purposes.
Do you disagree with what Attorney McGinty said, that if we find that the statements were made during an unlawful search, that they should be suppressed?
No, it's clearly the rule is that it has to be the fruit of the illegality. And if the illegality occurs after the statements are made, then the statements are not governed by the illegality, are affected by the illegality.
I mean, is it as simple as he said that once they exceeded the reason for the Terry stop, that anything after that should be suppressed?
Yes, that's the law.
It is that simple. Okay.
If there are no further questions, the Commonwealth will otherwise rest on its brief.
Okay. Thank you. Thank you both. Very interesting case. And it is submitted. All right. Number 3 for this morning is Commonwealth versus Mark Romanoff, 24P804.
Morning.
Floor is yours.
Okay, great. Good morning, Your Honors. May it please the Court, I'm Frederick Bartman, and I represent Mr. Romanoff. In his brief and the argument on appeal is that he didn't receive a fair trial for 2 reasons. One, because of evidence that was excluded, and one because of evidence that was admitted. With regard to the first issue, whether or not the written release plan that was created and testified about should have been admitted into evidence. The cornerstone of that argument is that by not admitting it, the court created an imbalance in the evidence that the jury ultimately took with it to deliberate his freedom.
How do you respond to Attorney Crane's argument that you're reading the imbalance thing way too broadly, that it's limited to the examiners and mental health examinations?
Sure. So referring to the Santos case and cases that interpret it, they made that argument because, or made that finding in the law because first the examinations, reports, and opinions of the qualified examiners are, by legislation, essential to a determination of whether or not the offender is sexually dangerous. Then they go on to point out the radical departure from the rules of evidence that much of the evidence admitted at these trials is hearsay, totem pole hearsay, reports of other people that are then incorporated into the qualified examiner reports. These written reports by statute are allowed to be admitted into evidence and considered by the jury, and then they turn and look at the statutes and have to reconcile whether or not it would be a fair trial if appellant's experts' written reports wouldn't also be admitted into evidence. That is not intended to be an exclusive statement about imbalance of the evidence, but it was very helpful evidence to guide the trial court and appeals court in terms of an ongoing obligation to ensure that there is not an imbalance in the evidence. And so when you also look at the qualified examiners' opinions with regard to release planning, whether or not the public is safe without appellant being confined to a secure facility, the nature of release planning and the details of release planning are essential. They're virtually an element of the offense that needs to be proven.
So let's assume you're correct that we need to tweak the rules of evidence or tweak what evidence is permissible in these cases to ensure that there's no imbalance. How was there an imbalance here where the Commonwealth's witnesses testified what they anticipated would happen upon release, and the person who developed and wrote the written release plan also was permitted to testify about what she did?
Thank you. That's a fair question. I would argue that the imbalance lay in, first, that the qualified examiner's report itself made reference to the release plan, and they made reference to it in a negative way, both in terms of the inadequacy of it to the extent that they commented on it in detail and accurately, to the extent that they then referred to appellant having no idea what was in that police report and in the release plan and being seemingly indifferent.
Well, certainly that evidence could be rebutted by calling the respondent as a witness, and the written release plan itself didn't address the issue of how familiar the respondent was with its contents, did it?
Well, and the third point is that, as stated in these written qualified examiner reports, and again I refer to Dr. Peretti in particular, there was a very general statement, a vague statement about, oh, there's services in this report. And so you have that combination of evidence that goes in front of the jury during their deliberations. And whether or not appellant had testified, ultimately, when the jury was deliberating, they would have the written reports of the qualified examiner, and at best they would have to rely on their memories about the detail of the release plan itself. And the other thing about the unfairness of this and this particular issue is that, and again, it's really completely unrelated in terms of the analogy, but I think it's the Marquardt case that talks about that Nalprost cases, the police reports from Nalprost cases can be provided to the jury, to the qualified examiner, but they can't include the details of that police report in their reports or in their direct testimony, that would be a backdoor manner of admitting inadmissible evidence. Well, in this particular case, if you're going to argue that the release plan is inadmissible, then it's not fair that it was included in a biased way and in a vague way in the qualified examiner reports, and then not have the release plan itself available for the jury.
Can I just ask you a step back for a second? You're not arguing that the plan was admissible under some exception to the hearsay rule. You're conceding it's hearsay, but you're saying it should be admitted anyway, right? Is that?
Well, I am. I mean, I'm conceding it's hearsay, and the vast amount of evidence that the jury considers over and above testimony is hearsay. I mean, that's what the legislature decided, the so-called radical departure from the rules of evidence, and there's a logic to that in terms of not recalling victims of crimes and clinicians that are doing the boots on the ground work and so on. But then what the courts have been doing is making sure that that doesn't create an imbalance in the evidence.
And I ask you also to address the Commonwealth says that that you haven't even raised this issue before, that it's your due process issue with respect to the release plan is being raised for the first time on appeal. How do you respond to that?
Sure. I suppose that's accurate. That specifically in the motion, which was the Commonwealth's motion to exclude it, there wasn't any issue raised, and then in the court's determination of that issue, that particular reason wasn't raised and then dismissed. But I would respectfully say that you can't know all the issues upon which to base a legal argument before your honors at the time that the trial court is initially making its determination, and that the issue itself was adequately preserved in order for us to then make a due process argument on appeal.
You've no claim that except for putting the document in, that the examination of Dr. Patz was constrained in any way that?
No, it was not. I think the trial court was aware of the imbalance, frankly, and there's even, I think I footnote the hyperbole that was offered by the trial judge that they should amend the statute. This report should be admitted into evidence. And my argument is you don't need to do that, that we need to have an appellate interpretation that under the circumstances, certainly of this case, and the way this issue unfolded, that report should have been admitted into evidence. And one last point I want to make is that, I think it was in Santos that they talked about reconciling all the statutes to avoid the constitutional issue. And they looked at, I believe it was Section 9 trials and the language around what was a report versus an evaluation, and that language wasn't on all fours with the rules of evidence for Section 12 trials. And I believe that the determination was we're not going to overemphasize that ambiguity or difference in the language. We need to reconcile those two statutes and frankly integrate the language, because that's probably what the legislature would have intended. And I would make that same argument here, because if this was a Section 9 trial and it was a release plan that was considered by the CAB, the Community Access Board, and it was included in their reports, then this would become explicitly sailing into evidence at trial. So this issue has been considered by the legislature, and I would ask the court to reconcile the statutes in a manner so that Section 12 litigants get a fair trial. If I can, I would like to address the second issue with the court. Thank you. So that's the piece of evidence that appellant argues was improperly admitted into evidence, and that is 20-year projected rates of reoffending. I guess I want to say at the outset that respectfully, I don't think this is a Dalbert Lanigan issue. This is not science, this is math. This is projected statistics that are well documented in insurance law and our insurance practices, and that the issue here is relevance and speculation, and is there a foundation that there is any actual evidence upon which to determine whether or not appellant was likely to reoffend. 5-year projected rates that form the basis for the actuarial, the static 99R, those are based on known offenders that were released to the community, and then there's science applied to it, and they have group rates based on particular categories that they base those percentage likelihoods of reoffending. Without those 5-year rates, without those known offenders, we don't even have a static 99R. And then the 10-year rates are also based on known offenders, metadata from meta-analyses of released individuals, and those same group rates are determined for actuarial use. 20-year rates are neither. And the learned articles, the peer-reviewed articles that I cite, and the creators of the static 99R, they all warn the courts and the litigants that there is a danger in misusing projected data like this. And so
I know you're arguing that the judge should have excluded it from the beginning, but the danger of misusing it was raised at trial, right?
Excuse me?
The experts did talk about there was a lot of testimony about whether or not the 20.
Sure. But the jury is left with the evidence, and it's hard evidence. It's in Dr. Peretti's report. It's a basis for her finding that he remains dangerous. The danger is, I think, I'm trying to remember the constitutional law treatise that goes back to 1978 for me, Lawrence Tribe, that trial by mathematics, and that the jury hears that percentage possibility of reoffending. They're left with two notions: that 20-year rates of reoffending are relevant, and that some projected rate that has no actual basis in the evidence ought to be applied to whether or not appellant is a risk if not confined. Thank you very much. Or, I'm sorry, I'm way over.
No question? Any question? Okay, no, thank you.
Thank you.
Oh, wait, he doesn't, we do.
Yeah, I do have one further question. You said a moment ago that you didn't think this was a Daubert-Lanigan issue at all. Wasn't it argued that way to the trial court, though, where the respondent moved to exclude this evidence because it didn't satisfy Daubert-Lanigan, and that motion was denied?
Yes, but I think two things with that, Your Honor. One is that the court so ruled, but my sense of the way the appellant's attorney was arguing that was, I would say, arguably also the issue that I'm raising, that there just was no evidence upon which to support a finding that this ought to be admitted.
Thank you.
Thank you.
Good morning, and may it please the court, Jesse Crane for the Commonwealth. I'll start with the issue of the PATS release plan first, and just note that the threshold question is really whether the trial judge abused his discretion in his order, which was, to be precise, excluding the written report but allowing the social worker to testify. I think that is a reasonable alternative to exclude inadmissible hearsay, but allow the social worker to testify to the substance of the plan. That way the defendant could present to the jury all of the resources that he would be able to access in the community were he to be found not sexually dangerous. And I think as a result of that ruling, there really was no imbalance in the evidence. Ms. Pats was able to testify to the substance of the plan. The QEs and the independent experts all factored in release planning in different degrees to their written reports, but to the extent that there was some debate among the experts as to how release planning factored into sexual dangerousness, that was for the jury to resolve. And it's not clear why admitting the written plan would rebut some of the issues raised by the QEs in regards to the respondents' understanding or comprehension of the release plan.
What do you say to the respondent's argument that this plan, if this were a Section 9 proceeding to determine if he were still sexually dangerous or instead should be let out of the treatment center, that this sort of plan would come in, at least if it had been considered by the Community Access Board, and therefore to preserve the sort of symmetry that we expect between Section 9 and Section 12 proceedings, it should have come in here as well?
I guess my initial reaction is I don't believe that was fully raised in the respondent's brief. I think it is a slightly trickier question as far as balancing the two proceedings. My substantive response, though, would be that because this was prepared by an outside entity rather than the CAB, it doesn't have the same indicia of reliability that we ascribe to the enumerated documents that are admissible under Section 14 and Section 9. So it is a slightly different document than what would be prepared by a petitioner in a Section 9 proceeding pursuant to like the CAB process who has gone through sex offender treatment.
So in Section 9, is it the CAB itself that prepares the plan? Or someone from within the treatment center, or otherwise a Commonwealth employee versus someone retained by the respondent?
Candidly, I'm not as familiar with the Section 9 proceeding, so I don't want to speak authoritatively on that since it's not in the record and I haven't reviewed it. My understanding is that this is something that the offender, him or herself, prepares well at the MTC as part of sex offender treatment. So it's under the umbrella of the CAB rather than an outside entity. If there are no further questions on the release plan, I will just quickly move to the second issue of the 20-year rates of reoffending. Respectfully, I would say the 20-year rates are expert testimony, they would be subject to Daubert-Lanigan. The respondent in his motion in limine did attack them on Daubert-Lanigan grounds, but then didn't move for a Daubert-Lanigan hearing. So to the extent that the issue is scientific reliability, that issue is waived. There's really not sufficient factual findings or expert testimony to enable this court to fully flesh out whether the 20-year rates are scientifically reliable. And I would just note that to the second piece of that, the 20-year rates were helpful to the trier of fact. They provided a rough estimate on an actuarial basis of what the rate of reoffending for similar offenders were. That's obviously helpful to a trier of fact whose job is to predict the likelihood of reoffense.
That, I can see how that would be helpful if this respondent were in his 20s or 30s. But this respondent was, if I'm not mistaken, in his 60s, late 60s?
He was 67 at the start of trial and 68 by the end.
Okay, so you've got in the evidence, and it's not challenged on appeal, about the recidivism rates over 10 years, the 10-year period after release. That would bring him up to age 77. And we know that age, advancing age is a factor in decreasing the risk of recidivism. So at some point, doesn't the probative value of recidivism data get outweighed by the prejudicial value? If you hear that people who've been out for 20 years reoffend at a rate of a total of 23.8% or whatever it might be, but by the time he's been out for 20 years, he will be 95 or 96. So how likely is, doesn't that high number, a high recidivism rate, kind of create an undue prejudice because it's not realistic in the case of someone that old?
I think that number was given in the context of all of the limitations of the static 99R. And I will just note that Dr. Peretti in cross-examination did explain age is factored into the static 99R from the get-go. And there wasn't robust literature supporting the idea that there was a further drop-off in reoffense after age 60, which is, at least for purposes of the static 99R, the point where an offender gets the lowest possible reduction in the rate of reoffense due to his age. To the extent that perhaps the literature might expand in the future, that might be something that would be dealt with differently. And I would just add that all the examiners explained, this is a limited tool. You need to factor in other dynamic factors as well. This is not a rate specific to Mr. Romanoff. This is a rate specific to other offenders who have a similar score. So the jury, I think, would have understood that this is not a crystal ball into the future for Mr. Romanoff. This is maybe a baseline explanation of what the rate of reoffending was, and you have to take in the other factors, the dynamic factors that all of the experts considered as well.
And just so we understand, the 20-year figure, the 5 and 10-year figures are based on the observed rates of reoffense for people who scored a 5 on the static 99R. The 20-year rate that was at issue here is based solely on a statistical projection using those 5 and 10-year rates. It's not based on following people who had a score of 5 for 20 years and seeing how much they reoffend.
No, it's not. I would say that I think the record does show, however, it was based on those observational studies, and they determined that there was a consistent rate of desistance over the time that the observed offenders were released into the community. And they used that consistent rate to project out. So I would say it's really more of a mixture of the observed data and statistical analysis.
So desistance meaning decrease in recidivism rate?
It's the desistance in terms of not offending every year they're out in the community.
Okay.
If there are no further questions, I will rest on my brief and ask the court affirm the judgment.
Okay, seeing none, thank you. Thank you both. Very, very well briefed and well argued on both sides. You ready for one more? One more, okay? Okay, we're going to hear one more case, and before we take our customary morning recess, and that case will be 24P 1442, GUINANE versus FITZGERALD. And counsel for the petitioner will correct me if I got that wrong. Okay.
Morning, Your Honors. Edward Gaynor for the appellant, Barbara GUINANE. The issue presented in this case is basically whether a licensing authority has the discretion to deny an applicant based upon alleged bad conduct of a household member where the applicant themselves is otherwise a suitable person. I know that the court has read the materials in my brief and my brother's brief, so with the court's permission, I'd like to just kind of dive into some of the issues.
Did you also receive the order about being prepared to discuss what statute we should be applying here?
Those were the issues that I wanted to dive in because I know the time is short and arguments can be long. With regard to the first particular inquiry that the court had as to which statute should apply when the chief makes his decision, it's fairly obvious to us that the later statute should apply without the existing factors verbiage in it. In August of 2022, the Supreme Court of the United States came out with the Bruin decision recognizing the Second Amendment as a fundamental right to bear arms and not a second-class right, and that's language from the decision. The legislature in Massachusetts in August of 2022 came out with the new statute eliminating that existing factors language, and I don't think that it takes a Kierkegaardian leap of faith to realize that this amendment was intended to comply with the U.S. Supreme Court's directive. Further, the amendment predates the chief's decision by some 3 months.
Does it even predate the application?
Pardon me?
Does it predate your client's application?
It predates, it doesn't, I don't believe it predates the application, but the decision itself of the chief happened some 3 months after the statute was changed. And I would respectfully suggest that in view of the statute having been amended and the United States Supreme Court giving a constitutional directive about what the rights are for somebody to bear arms, and you know, you may not like the directive. I don't like the directive. I don't have a gun in my house, but it is the directive. Those two factors put together mandate that the second statute be the one that's recognized in this particular case.
So did the chief apply the correct statute? Or did the chief apply the older statute?
He applied the older statute without naming the older statute by name. His basis for denial was, in essence, existing factors. He recognized at the hearing at the district court that Barbara GUINANE, this woman is Caesar's wife. She has no criminal record. She passed.
We know the facts. So we know the chief said we've got that. Right. He said that it was really her association with her husband that concerned him. So, given your position that he didn't apply the correct statute, what should we do here? Should we remand so that he can apply the correct statute, or so that the district court can take evidence under the correct statute? Or should we decide the case based on the record that was already developed, but applying the correct statute?
Which brings us to the second question in the memo that Your Honor sent out. Obviously, the optimal decision from my client's perspective would be to reverse his decision and send it back to him with instructions to issue the license forthwith.
But is that the fairest thing?
That's the fairest, we believe.
Well, that's the most advantageous to your client, for sure. But do we know that if the chief had applied the proper statute, whether he would have come out differently, or whether additional evidence would have been developed at the evidentiary hearing in district court?
Well, I think he would have had to have come out differently because he said that she was otherwise suitable. He would have given it to her if she wasn't associated with the husband.
Well,
and he
let's
also
test that. So if we're dealing with the statute that doesn't have the existing factors language, that only refers to reliable, articulable, and credible information that the applicant or licensee has exhibited or engaged in behavior that suggests the applicant or licensee may create a danger to public safety. What if the applicant says, and this is hypothetical, it's not these facts, bless you. Suppose an applicant is fully responsible, but says, well, I know that under the statute, I'm obligated to keep the firearm in a locked container so that only I can use it. But of course, sometimes I'm kind of forgetful. And by the way, my roommate, who had his gun license revoked, sometimes makes me do things I don't want to do. So, can that be considered under the correct statute as a ground to deny the license?
I think it probably could be. I mean, if it was that egregious of a factual scenario, I mean, of course it would be. But that's not the situation that we have here. She's got a biometric lock. She's got a safe.
Right. I noticed that she wasn't cross-examined at the district court evidentiary hearing. Now, I don't know whether that's because counsel for the chief thought there was nothing to be gained by cross-examining her, or what the reason was. But if the chief wasn't applying the correct statute, and it appears that the district court and superior court were applying the same version of the statute as was the chief, does there need to be an opportunity for the chief to submit more evidence before the application is ruled upon one way or the other?
Not really sure what he could possibly submit. He already submitted at the district court level that Mr. GUINANE had something in the nature of an injunction against him and had been arrested for allegedly threatening the neighbor, both of which have been dismissed after being quaffed in the interim. He said in open, well,
that's not something that was before the chief or the district court, correct?
It was something that came out of the chief's mouth as a reason for denying under...
No, I mean the quaffs in the two pending charges. They were pending at the time?
No, they weren't even quaffed they were quaffed in August of 2000, the probation ended on it in August of 2024 and November of 2024.
Right. So where the chief,
well after.
So where the chief relied on the pendency of those criminal charges, wouldn't it be advantageous to your client to have the chief consider the application without regard to those charges because they're no longer pending?
I don't think it matters, because what we're doing then is we're shifting, in contravention of the statute, the focus from the applicant to the husband. And there was plenty of testimony taken at the district court level about how careful she was. And to get a second bite at the apple and, I mean, what would it show? What could it possibly show? I mean, we're just shifting the focus to somebody that the statute and the Supreme Court case more or less clearly says should not be the focus.
Well, you've agreed that the applicant's behavior or predicted behavior that might make the firearm available to a prohibited person could be taken into account. I think you agree that in response to the hypothetical earlier.
Yes,
So-
but the chief has already determined that she's otherwise suitable. She's got the background checks done, she's got the firearm safety done, she's got the proper safety mechanisms done. I mean, honestly, if he was to say, gee, do you think sometimes you'll forget to lock the safe? I mean, what's she going to say, right?
Well, I don't know what she'll say.
Well, she's got, I think you could assume.
I know what she would be urged to say, if it were the truth.
If it were the truth.
Sure, sure. I noticed that in the closing argument in the district court, counsel stated, I think it was you, I'm not sure.
It wasn't.
It wasn't you, okay. Counsel stated, referring to the applicant, she stated under oath that she is not going to allow her husband to use a gun. I didn't really see that in her testimony. All I see her doing is agreeing that she's aware that as a person that had a license to carry would not be giving a gun to someone that did not have a license. That seemed to be kind of lukewarm. It seemed to me that a stronger statement by her would be, I'm aware that it's unlawful for me to allow someone unlicensed and prohibited to have access to a gun, and I won't be allowing my husband to have access to the gun. Now, whether or not it's her burden to establish that is a separate question, but wouldn't it be advantageous to her to have that evidence in the record?
Well, it wouldn't be as advantageous as directing the chief to issue the firearm license forthwith, which is what, on this record, is the fairest approach. Not just to my client, but in terms of, respectfully doing justice.
Well, we're trying to be fair to both sides.
I know.
So should the chief get another shot? Is there anything to be accomplished by a remand?
I think he said anything that he has to say already.
How do you respond to, I think it was Judge Rooney in the district court saying that the chief believed the application was a pretense to allow your client's husband to keep the firearms that he had inherited from his father, some testimony about inheritance?
Well, again, the chief is speculating. Temporal connection does not mean causation. She did apply for the license shortly after he lost these from these alleged transgressions. But on the other hand, there could be 100 reasons that, she was applying for the license at that time. It didn't have to necessarily be anything nefarious. The husband might have said to her, well, first of all, she had elderly people living there. She had, I guess, bags of cash living there with them. She was home with the elderly people a lot. They don't live in a very isolated area, but it's set back. And the husband could have said to her, look, I don't have a gun anymore. I can't protect you, my love. It's if somebody breaks in.
She has no burden to prove a need for self-defense anymore.
No, she doesn't.
But I'm asking about she testifies, I'm not sure whether this is on page 42 of the appendix, I'm not sure which case this is. I was supposed to get the inheritance in the form of guns that my husband's father left after his death. My husband, his license is suspended, so he can't get it. So it sounds like she wants a license to get his guns.
She wants a license to get one of her own guns, I believe. But there are also antique guns, and it was unclear from the record whether they work or whether they don't. But at least one of them, she wanted a gun that shoots. And, I think that on that point of fact, okay, the chief is looking at it, he's, all right, maybe there's something fishy. I don't like the way this smells. But his mere suspicion does not trump her First Amendment right as a law-abiding citizen to get her gun license. And again, that is shifting the emphasis away from the applicant, where the statute and the Supreme Court have the focus now, over to a person that the focus is not supposed to be on. The only other thing that I wanted to address, and I'll do it very quickly, is the Chief of Police of Southborough versus Diggins case. I'd assert it has very limited applicability to this case. It was decided on a 2020 version of the statute. It does provide some guidance. As Judge Desmond said in his dissent, the factors, existing factors is very nebulous verbiage. And somewhat unfathomably, the case was argued in 2024, and no constitutional issues were raised, per footnote 2. I see my time is up. Unless your honors have any further questions for me, I'll rest.
Okay, seeing none.
Thank you very much.
Good morning, Your Honors. My name is Brian Riley with KP Law. We're town council to the town of Manchester by the Sea, and I'm here on behalf of the appellee, Chief FITZGERALD. I would also like to quickly address the first two issues that the clerk's office sent us. I do agree, even though it kind of makes my job more difficult, I do agree that the statutory language that became effective in August of 2022 is what guides here, because according to the information I have, the appellant, Ms. GUINANE, her application was filed in October of 22. The chief denied it in November. So I think that so I do think that the amended language, amended in August, is what applies here. I do think there are still good reason to affirm this judgment, which I'll get to. But on the second issue of if the court thinks something else needs to happen with this, where should it go? Obviously, if you remand it to the chief would treat it. But I think the chief made his decision, not reading the statute, but just he knew what was going on in the neighborhood, the outstanding 258E orders, et cetera. And he just felt, I just can't be comfortable putting firearms immediately back into this house. I just took his license. He's a prohibited person. But that the district court, Salem District, heard the testimony, saw the exhibits, made its conclusions, and I think if this court thinks the law has changed and we need someone to take another look at this, I would think Salem District Court might be the appropriate remand, but obviously we'll do. This isn't a major issue in this.
Let me just follow up on that. What you're suggesting, I think, is that there would be an additional evidentiary hearing in Salem District Court, or just purely remand to ensure that we're applying the correct law to the facts that were already developed?
I mean, I guess either. Perhaps it wouldn't necessarily need another evidentiary hearing.
Do you think there's any additional evidence that the chief would offer that would be useful at an evidentiary hearing?
I don't think...
Since the parties agree that the existing factors language is no longer in the statute, would the chief have anything additional to say, knowing what the correct statutory language is?
I don't believe so, Your Honor. I don't. This isn't a major issue in the case, but I did just want to comment on something my brother said. The changes that were made to the statute in August of 22, the suitability was not something that came up in Bruin. The changes that they pointed out were a problem in New York and Massachusetts was where if a applicant not prohibited, not unsuitable, the statute said the chief may issue them a license. Bruin says it has to be shall. That was changed. And Massachusetts also said, well, you also have to demonstrate a proper purpose for wanting a license to carry. Bruin didn't like that, and the general court struck that as well. I was not able to find why the general court took up the suitability test, so to speak, also in August, but they did. And let's see. I guess I would just point to two things as to why I think there are grounds to still uphold the Superior Court decision in this case. One, in which the Superior Court was looking at the District Court's decision and seeing if it found an error of law. And the District Court, in their decision, said that the timing of Ms. GUINANE's application shortly after her husband's license to carry was suspended by the chief lends credence to the chief's belief that her application was a pretense to allow her husband to maintain access to firearms. Now, the appendix includes the transcript from that hearing. The chief did not actually say that. He did say he was very concerned to the point of not being able to approve this application that firearms were going to go back into the house. But I think that the district court judge kind of took what Ms. GUINANE testified to and, maybe made her own conclusion that there may be something to that. And then the Essex Superior Court also found that the chiefs had reasonable concern for public safety here, and that Ms. GUINANE's testimony concerning having a biometric gun safe and trigger locks was not sufficient to eliminate those concerns, the chief's concerns, entirely. And I guess the last point I would make...
Can I follow up on that point?
Oh, sure.
You were drawing a distinction between what the district court said and what the chief said. Is the chief taking the position or disclaiming the position that this application was a pretense or a pretext for obtaining access to firearms for the husband?
I don't think the chief is disclaiming that. I was just pointing out that the district court wasn't quoting his testimony.
So is the chief relying on that?
I do think that it was very significant to the chief when the application was filed. It was right in the middle of her husband losing his license, right in the middle of 250-80 orders out there, all these incidents in the neighborhood, fear in the neighborhood of what was coming out of that house.
So are you saying that part of the chief's rationale or thinking about denying this license was that she might be applying in order to get her husband access to firearms? Or is it just the concern that she might be a volatile person and use?
No, I think the chief's focus was on the husband, but that I really think he felt so strongly about not being able to approve this application. I do think that was in his mind, that a risk to public safety could increase if I grant this application. And
doesn't he have to base that determination on characteristics of the actual applicant in front of him? That something about her would create a risk that...
I'm sorry.
Yeah.
That was one of my last points here. The language that came in August of 22 talks about information that the applicant has exhibited or engaged in behavior that suggests...
And that was there
right.
before 2022 as well.
And I do think that if the chief had to point to, well, what was the action of Ms. GUINANE that you think created a risk to public safety, I think it's the fact that she applied when everything else was going on with her husband, which gave an impression that maybe this is a way to try to keep guns in the house. Like I say, he didn't state that in his testimony in the district court, but I certainly think it was on his mind. The district court connected those dots. And I guess my final point, and I'll rely on the brief otherwise, is that, in my opinion, if the court kind of goes down the road that the Dwiggins decision started and says, these are my words, a chief of police, when they get an application, they have to kind of put blinders on and only look at the applicant. And if they don't have a criminal record, the police haven't been showing up because of something they did in their house, then I have to give them a license, regardless of the environment that this person is in. I think that's a significant change in the last 40 years of case law about how broad the chief's discretion is and why that is to protect public safety.
There have been other changes in the last 40 years of case law that might tie everybody's hands.
Sure, sure. But I do think that there is a way to read the current statute, or the statute as it read when the chief denied the application, to say that it was the action of the appellant, Ms. GUINANE, in applying when she did, with everything else that was going on in that, in the house, if you will, that was the action which the applicant took that led the chief to conclude it may create a serious risk of public safety. And for that reason, we would ask that the judgments below be affirmed.
Can I just ask, in the denial letter that was sent in November of 2022, the chief of police states that she's unsuitable and then gives a paragraph of his explanation, and it says, in light of recent events involving multiple police responses to your home, along with outstanding court orders and complaints on your family members. Do you know, were there police responses to the home outside of the harassment order and the arrest of, I think there's two police, two criminal actions, or excuse me, a harassment order and then a criminal action with the gentleman. Were there police responses in addition to those two events, or are the police responses just those two events?
I think I know somewhere in the testimony of the district court where Mr. GUINANE destroyed some property of a next-door neighbor. That was certainly one of the times the police came. I think there were some where neighbors were saying, he's in my backyard or something along those lines. It wasn't anything violent per se, other than destroying the property. But I think basically the reference to the police responses was to what led to those harassment orders and the destruction of property. Unless there's anything else, I believe I'm concluded.
Okay, no, seeing none, thank you both for your presentations.
Thank you.
So we're going to take a 15-minute recess, and we'll come back to hear the fifth case.
All rise.
All right, calling case number 5 today, 24P956, RAUHAUS, FREEDENFELD and Associates versus CARROLLTON West Pet Hospital. Good morning.
Good morning.
Still, yeah.
Good morning. May it please the panel. My name is Joe Comenzo, along with co-counsel Tim Fallon. We represent the appellant in this matter, CARROLLTON West Pet Hospital, and we're here this morning to ask this court to remand the matter to the trial court to take additional evidence as to the cost of the construction of the project at issue in this case. We offer this panel a few roads to get to that destination, and in order to understand the plaintiff's argument and the issues that it has with, or sorry, the appellant's argument, the issues that it has with the trial court's findings, it's helpful to take a 50,000-foot view of what the trial court found. The court found that the longstanding contractual relationship between these parties ultimately and irrevocably dissolved in 2015 after this project went out to bid for a second time because appellant believed that it could build the project that RFA designed for $4.5 million or somewhere in that neighborhood, and appellee didn't believe that that was possible. And the trial court also found that at the time of trial, appellant had contracted with Mike Villalobos and Marcon Construction to construct the project, and it was 50% done at the time of trial. And those two facts are really what complicate the analysis and confound the trial court's decision. Once the trial court determined that the addendum was void and that the parties' relationship was governed by the prime contract, the court was instructed, or is supposed to read the contract as a whole so as to give its effect as a rational business instrument in a manner which will effectuate the intent of the parties. And when the prime contract is read as a whole, where the architectural fee is a percentage of the total cost of construction, and where there's a contract for construction in place between the owner and a contractor.
Total cost or estimated cost. Isn't that what the prime contract says?
That's the term of the prime contract that was employed, but as opposed to it being a flat fee for service or an hourly fee for service. So when it's a percentage of construction cost, be it estimated or not, but when the fee is a percentage, and where there's a contract in place between the owner and a contractor to build the project, and the project's underway, then the aggregate cost to the owner, or the total cost to the owner, is the aggregate cost under that building contract for all the elements of the project as designed by RFA. In order to arrive there, you look first at Article 11.2.2. That sets out the components of the base fee. The components of the base fee consist of the programming, the schematic design, the construction documents, the bidding and contract negotiation, and then you have construction administration. During the first 4 portions of that contract, the first 4 components, the percentage or the base fee fluctuates. It's $18 a square foot, and this is what the trial court found. This is what happened to the parties. It's $18 a square foot, then you get an estimate, and it's 8% of that estimate, and it fluctuates 8% of the bid. However,
payments going on during that time?
Yes, they are. The payments are going on, and they're being invoiced, and the total amount due fluctuates, which is why in 2012, my client got an invoice for $180,000 when very little work had been done on the project because a new bid came in, a new cost came in.
So why is it ever necessary to rely on estimated cost versus the cost of the work that's actually been done to date?
Well, this is an architectural contract, so the actual project beginning doesn't happen until the very end. So I'm talking about the first 4 phases of the architect designing the project. And during that process, the base fee, the architect's base fee fluctuates. As they get a new bid comes in, then it fluctuates. So it starts at one thing and it moves back and forth. However,
I mean, but and actually, just to ask the opposite of what Justice Sachs just asked, looking at 11.2.2, 90% of the fee is supposed to be paid by the time of bidding and contract negotiations, which is well before anything's going to be constructed, right?
Correct.
I mean, so it's almost always going to be an estimated cost.
It's always going to be an estimated cost up until the construction administration component. Once you get to construction administration, which according to Article 2.4.1 commences with the award of a contract for construction between the owner and a contractor. And then from there, if you look at Article 12.3, the fee for construction administration, which is that last 10% of the base fee, shall be divided equally into weekly amounts over the period of time set aside for construction as stipulated in the owner and contractor agreement. So therefore, once the contract between the owner and the builder is in place, the base fee is set, it's known, it's a whole figure, which is why appellant argues that once that's known, that is the total cost to the owner, which makes sense because the owner has a contract in place to build this project at a set price. And all things being equal, that should be the price the owner pays. And I would look also to Article 3.3, which indicates that any changes that are made during the construction phase are additional services. They're not covered under the base fee because the base fee has been set. Therefore, the trial court's
but what if the cost of construction, once construction begins, turns out to be substantially less or substantially more than the bid? Is the architect's fee adjusted up or down?
I imagine that the architect's fee could be adjusted up or down, but I imagine
even if the architect's done no further work?
If the architect's done no further work, that would, first and foremost, that would be a source of a contract complaint between the owner and the builder. And depending upon the outcome of that, then perhaps the architect's fee may be adjusted. But if there's a contract in place to build the entire project, then that should be the cost the owner pays unless there is some breach, unless there's some unforeseen circumstance. And if there's
And that's based on the phrase total cost or the phrase estimated cost?
As I'll get to 5.1.1, 5.1.1 doesn't, when read in the context of the entire agreement, doesn't provide for the kind of analysis that the trial court has said. If you look at 5.1, and I'll get there in my argument, but 5.1.1, the estimated cost is, in fact, a category of costs that might not be reflected in the builder's contract, which is why it's estimated cost for any portion of the project that's not constructed or any estimated cost of materials and labor that are provided by the owner. These would be costs that the architect is capturing, which wouldn't be reflected in that owner-builder agreement, which sets the base for the total cost to the owner. But where total cost to the owner is set with the execution of a contract between the owner and the builder, then it makes the trial court's findings on page 17 incorrect, where the court found that as a practical matter, the project is only 50% complete. Therefore, total cost of the project cannot be calculated at this time. The trial court's conflating final cost with the contractual term total cost, because total cost is set at the time, it's set before construction begins. It's set at the time.
So why would there need to be evidence, such as you offered in your 59A motion, about actual cost? Or wouldn't there be?
It's an interesting question. If that is the interpretation, if this court adopted that interpretation, a de novo review of the prime contract, then it would appear as if introducing the total cost or the actual cost, you'd really be seeking to introduce the cost of the contract and what it's actually costing the owner to build the project, as opposed to an estimated cost from someone else, or an estimated cost in any way. You'd be looking at the contract price.
But your client signed a contract with, I forget
Marcon.
which. Okay, so that number is known. Why do we need to get into the actual costs being incurred, as you suggested you wanted to in the 59A motion, if we've got that contract with Marcon, or at least the number in the record?
Correct. In truth, my understanding of what we would be seeking has been refined, and I would seek both. You'd have to produce actual costs because of the issue with the site work that was done prior to and the moving of stuff and the stuff that the owner did himself. You'd have to produce actual costs for that, the cost of the materials in order to be able to calculate what the market rate would be. But the final cost, the actual, if he chose gold-plated fixtures and what kind of toilets he chose, that wouldn't be relevant to the architect's fee. Those are ways that the contract between the builder and the owner might go up, but they're not relevant. What you would need to know is what the actual costs were for those portions of the construction contract, which reflects the elements that were designed by the architect. And that would be the base of the fee. But understanding what because the trial court determined that only 50% of the project was done and therefore total cost can't be calculated at this time, that is incorrect where the actual total cost of the owner is captured at the time of the contract between the owner and the contractor. The only instances, and as I said, the owner's conflating, or the court was conflating the final cost with a total cost with the final cost. The only instances in the prime contract where estimated cost is the appropriate metric is Article 5.1.2, where the owner provides materials to the project, and then the architect captures the fair market value of the labor or services that the owner provided, and Article 10.3.4 for any component of the project that's deleted or otherwise not constructed. So the architect is capturing the work that they did on those portions of the project that weren't constructed.
We've been talking for 11 and a half minutes about the prime contract. Your first argument is that we should be enforcing the addendum.
I would move that to my second argument at this point. Yes, it's the first one presented.
And would your calculation of the price be any different if we were enforcing the addendum?
If you enforce the addendum only, the only metric reliable in the addendum is the estimated cost. And we would be asking the court to insert a curative term relying on total cost. And looking towards the prime contract to inform that. However, as I've looked at the prime contract, I believe that the language of the prime contract was misinterpreted by the trial court, and the easiest and most equitable thing to do is to uphold the trial court's decision as to the voiding of the addendum and govern these parties' relationship based on the prime contract.
So just as we're trying to write this up at some point, did you put that first argument to second, or are you actually withdrawing that first argument? It might not make a difference because it might be that your suggestion of the way we should calculate, or the way the damage should have been calculated, is the same either way.
I'm moving it to my second argument and requesting that that this court, if it were to insert a curative term, would insert a curative term consistent with the way it's calculated under the prime contract. I know that we offered some language. However, I think that the most equitable thing to do is to revert back to the agreement that the parties previously had and create a term that reflects the costs, or reflects the pricing in that regard. It is a negotiated contract between the parties. Appellant paid $42,000 for it, and it contains the waiver of attorney's fees that appellant believes he would be entitled to. So it would be an equitable thing, however, an equitable result. However, we would suggest that the curative term reflect more or less the way it's calculated under the prime contract.
I'm going to call an audible here. You got a minute left, but if you need 5 more minutes, this is a very complicated case. If there's stuff that you need us to say, and same for you.
I appreciate it, Justice Massing. I do. So I've argued now why I believe that the prime contract should be interpreted the way that we suggest in our brief when you read the entire contract, the whole contract. We also argue that the prime contract is ambiguous on its face, and this comes back to Article 5.1.1, which provides that it's total cost or estimated cost to the owner for all elements of the project designed by the architect. The ambiguity in that clause is twofold. First, it doesn't indicate who gets to choose, whether it's the owner, the architect, someone else. So it's ambiguous for the same reason that the addendum is ambiguous, because it doesn't have a mechanism for resolving that. But more importantly,
We need a mechanism in the contract itself for dispute resolution. I mean, some contracts have arbitration clauses or mediation, but if they don't, isn't the remedy a breach of contract suit?
it could be, definitely. If the ambiguity is that significant, or under the addendum, it would have been necessary because the addendum was the architect's fee was attached to the lowest responsible bid.
Right, I mean, there were two ambiguities that the judge found. One is, what does lowest responsible bid mean? And the other is, there's no mechanism for resolving that.
Right.
But lowest responsible bid is a term of art in the field. The fact that Mr. Barnes maybe misunderstood what it meant doesn't necessarily mean there wasn't a meeting of the minds. But assuming we conclude that term, lowest responsible bid, has an understood reasonable meaning in the field that could be applied, then why can't one party or the other take a position, okay, we think this is the lowest responsible bid, we think this is the appropriate compensation, and if the other party doesn't like that, they bring a breach of contract suit. Why do we need an arbitration provision or terms in the addendum that say who gets to decide what the lowest responsible bid is?
Under the addendum, the purpose of the parties, the express purpose was to get the project out to bid, or to get it underway, to get it constructed. In order for that to happen, a bid needed to be selected.
But lowest responsible bid, there's no mandate that the lowest responsible bid be selected, is there?
There's no mandate that the lowest responsible bid be selected.
It's only used in connection with how much the architect gets paid.
Correct.
The owner could select a higher bid to go with or a lower bid.
Correct, and it leaves open the possibility that the owner could construct the project at $4.4 million and pay an architect's fee on $7.2.
So why does it need to be decided under the addendum what the lowest responsible bid is in order to move forward with the project? That seems to me to go only to how much money the architect is entitled to.
I'm sorry, ask the question again, Your Honor?
Yeah. Why does it need to be determined what the lowest responsible bid is in order for the project to be constructed? Doesn't lowest responsible bid go only to how much the architect gets paid, not whether the owner hires any given contractor versus another to start building?
Yes, it would make sense that way. However, I question whether that would be a rational business instrument, whether that was really the party's intent to do that. In interpreting the contract, the trial court is supposed to, or this court.
Right, but suppose the owner says to the architect, okay, I get why you say this bidder is the lowest responsible bid, and I'm not going to fight you on that. I'll pay you whatever it is, 8% of that. But I think that this bidder who actually came in, $1 million less or $500,000 less, it in fact can get us what we want, and I'm confident they can do a good job, so I'm going to go with them.
That could certainly happen if the owner was willing to part with $160,000 or so, which would represent the difference in the two prices. However, it was interpreting the contract in that way, because at that point there would be a breach of contract claim if the owner didn't do that. To interpret that contract that way wouldn't be a rational business instrument. It would be inconceivable to think that where there's such a delta, that the owner would have intended, or the parties really would have intended, that this is how it should go, that we're going to base the fee on an estimate over here at 7.2, but in fact the project can in fact be built for 4.5. And so I would question an interpretation which led to that result.
But I took you off of the more important point you were about to make. I hope you can remember what it was.
I do. The 5.1.1 is also ambiguous in the term estimated cost. Every instance in which estimated cost is the metric for which RFA's fee is based, it's attached to something. In the addendum, it's lowest responsible bid. In the prime contract, under 10.3.4, it is lowest bona fide bid or negotiated proposal. Even in Article 5.1.2, it's attached to the market rate for the labor or services provided by the owner. To suggest now we're going to use estimated cost, not even a reasonable estimate. It could be your estimate, could be my estimate, could be my daughter's estimate. It's not even a reasonable estimate. The trial court read that into Article 5.1.1, that somehow it needs to be a bona fide bid or a reasonable estimate. It's not in there, which is why we say that that language is in fact a category of estimated bids or estimated costs that are strewn throughout the prime contract that the architect is entitled to a fee on. And it's only in instances where the project is, or portions of the project are not built, or where the owner provides materials or services or labor to the project, which wouldn't be reflected in the contract between the owner and the builder. So to suggest that 5.1.1 gives a choice, one or the other, is a misinterpretation of that clause. And the trial court or this court, when there's that kind of an ambiguity, would be looking by a traditional analysis onto what the party's intent was. And it's unrealistic, as I was just saying, Justice Sachs, it's unrealistic to think that the parties intended that Carrollton West Pet Hospital could build this project for $4.5 million. At this point, it's 95% done, and that's the all-in price. And RFA would be paid an 8% fee on a $7.2 million estimate. It couldn't have been the intent. There was no rational, or no competent evidence introduced at trial that that was the party's intent when they executed the prime contract. There's no rational business instrument, even one prepared by the American Institute of Architects for nationwide use, to suggest that that would be the result.
I had a question about that. It's dated 1987, this contract.
Yes.
Used nationwide.
Yes.
Is there no case law from other states that goes to the interpretation of 5.1.1?
I did not find any case law on that. That's not to say that it doesn't exist, but I didn't find any case law on the interpretation of 5.1.1.
I'm going to stop you there. See if there's, we're way over time. Let me see if there's other questions. I think we're going to have to stop it. We're going to have to stop it there. It's like 7 minutes over.
Thank you.
And this as well. But you know, obviously, we'll read your brief again and again. So.
Thank you very much, Your Honors.
May it please the court. Good morning, Justices Massing, Sachs, and Allen. My name's Ken Walton. Together with my partner, Patricia Gary, we represent RAUHAUS Friedenfeld Associates, also known as RFA. RFA is a nationally known architectural firm. Their expertise is veterinary hospitals. Warren Friedenfeld, one of the principals, has won over 40 national awards for his design of these type of hospitals. We are here today asking that the trial court's decision after a bench trial be affirmed. As the court knows, the standard for findings of fact after a bench trial is clearly erroneous. The Lincoln case, the Nintendo case, the Demoulas case are all very helpful in that area. The first argument I was going to make was to address Judge Tingle's discussion of the addendum. It's a little unclear to me whether my brother is now waiving that argument in arguing that Judge Tingle was correct in applying the baseline contract, the AIA contract, to this particular case. However, we certainly agree that that was what should have been done and what was done. And to answer Justice Sachs' question, I agree. There's no, unfortunately, on 5.1.1, even though these contracts have been used nationwide, there is no particular definition of those terms. However,
no case law that explores the meaning of 5.1.1?
No, Your Honor. But I would like to touch on a couple points that were raised by you and Justice Massing that lead to this discussion. Well, the actual words obviously are total cost and estimated cost. Total cost is when you know the total cost of a project. And there are two problems at stake with that issue at the time of this trial. First of all, the project was only 50% complete. And that wasn't Judge Tingle just picking that number out of the air. The Carrollton's own witnesses, their architect and their contractor came in and said, this project's only 50% complete. We don't know. We don't know how much it's going to cost. That's factor number one. Factor number two, which Judge Tingle talks about in his order, that's very important, is there was two series of testimony by Mr. Barnes, who was the principal for Carrollton. In the first instance, he said, oh, I didn't do much work at all on this project site. And, you know, I didn't, quote, self-perform work. Then we had a witness come in named Mr. Osborne, Chris Osborne, who testified that he was the project manager and that, in fact, Carrollton did substantial work on the project. Substantial work including removal of soil and concrete, drilling, fencing, the rental of heavy equipment, grading, excavation. So what was happening here, members of the panel, is that Mr. Barnes was averting the terms of the contract by self-performing work so that he could reduce the total construction costs and not have to pay the architect what he was due. And when pressed, so Mr. Osborne testified.
But under the defendant's position, the architect still gets paid for that under, what is it, 5.1.2?
Right. No, I agree. And
so agreed that he changed his story, but why does that matter to the result here?
Well, it circles back to this point, that with regard to 5.1.1, the only analysis that could be used here is estimated cost. That's it. Because there is no other way to get to the number of how you calculate that 8%. Because of the fact the project was not complete and Mr. Barnes had gone off and done literally millions of dollars of work that was unquantified. So Justice Tingle looked at the contract, he made an interpretation of it, and he said, I'm going with estimated cost. He then looked at the TriStar bid. This was all very logical. He looked at the TriStar bid. He listened to Mr. Friedenfeld, who's been doing this for close to 50 years. He listened to the factors that go into a reasonable bid, and he said, I agree with that. And I would argue that the Brigade case, SJC case, states contract language that is only ambiguous if it is susceptible to more than one meaning. Estimated cost is estimated cost. You don't know the actual number, so you use an estimated cost. Now, I want to return, because all these questions are dead on that the panel asked, to Justice Massing's point about how the contract is structured. There is a breakdown in the contract in section 11.2.1 and 11.2.2 that shows how the architect is paid. There's programming, schematic design, construction documents, bidding and negotiation, and then the last 10% is construction administration. The level of design work that goes into a project of this magnitude is substantial. We could roll in a cart of drawings that show the level of effort, thought, intelligence that go into creating that 90% that was indisputably done by RFA in this case. And I would say that the best compliment that Carrollton gave my client RFA is they were eager to use his design because it was a beautiful design. And Justice Sachs, to your point, they did build the project. So it all came down at the end of the day. It all came down to the end of the day, how much RFA is owed. That was the issue. That's the issue that we tried. And I will say this, to the party's credit, because I've been representing architects and engineers for over 25 years. To the party's credit, instead of letting this dispute over money crater the entire project, they did the project. They had this fight about the fee. They created an escrow account and set aside money to deal with that issue for a later date. And then we had a trial. And a trial is a trial. We both agreed, let's go with Judge Tingle, who, in my opinion, was an extremely thoughtful judge. I mean, we had motions in limine. We had sidebar discussions, which were obviously not at the sidebar. But
I don't think anyone's contesting that. Assume the defendants are right, the defendant, CWPH, is right, that the judge didn't interpret 5.1.1 correctly, and that you should use, if I understand the argument, the total cost as the contract price of the contract they actually signed for the building, but that you could use estimated cost for anything that falls under 5.1.2, that is work done by Barnes, and 10.3.4, which is items that were designed and scoped and all that by the architect but not built. Did you have every chance you wanted to introduce evidence of those two categories of costs?
yes, yes.
Okay. So if we decided that, if we agreed with them on the standard and the interpretation of 5.1.1, you don't see a need for a remand?
No, Your Honor, because, and I just returned to this point. The key word is or. That's the key word in that. It says total cost or estimated cost. Judge Tingle exercised his discretion and he said, I'm going with estimated costs, and then he provided a rationale for that. And that's what it says. If it doesn't say total cost, period, it says total cost or estimated cost. And there was no way, for the reasons I previously outlined, that total cost could have been resolved at that trial in February of 2023. Because the project wasn't done, and there was all this other work by Mr. Barnes that had been done.
Okay, but if it had been done up to that point, why couldn't evidence of the reasonable value of that have been offered and then added in under 5.1.2?
But, Your Honor, they never even tried to offer that as evidence.
No, but whose burden is it? You want the money. That would be additional money for you, as I understand it, under 5.1.2. So it's up to you to say, look at all this work he did. We're entitled to our 8% of the value of that work.
Well, but, Your Honor, I would return to my previous point, which is the contract says total cost or estimated cost.
And it's just up to the judge to choose whichever he's in the mood for, total cost versus estimated cost?
No, it's up to the judge as the fact finder to make a reasonable interpretation of that contract.
Okay, but if they're correct,
Yep.
that there can be adjustments, that total cost refers to the contract price of the contract signed with the contractor. And estimated cost refers to these adjustments that can be made for things that were unbuilt or that were built by the owner itself and therefore not included in the contract. Then why is that not a more rational interpretation than having to choose either total cost, meaning I'm not sure what you think it means, or estimated cost, which seems like the estimate in, I don't know, where do you get that number?
Because, well, he got the number from the bid, from the TriStar bid, and said, this is a reasonable cost estimate by this contractor, and I'm basing it on this number. So it wasn't, he didn't pick the number out of the sky. He said, it's a reasonable number upon which I am basing my decision. And the way it is written, the way that clause is written is clear. It's total cost or estimated cost. And yes, Your Honor, I do believe that the trier of fact has the obligation to make that decision, which factor he wants to apply. Now, one other point that was raised by Justice Massing, which is on when the fee is paid. There's no dispute in this court, I believe, that 90% of the services were in fact completed by RFA. They were done at the time of the trial. The last 10% is construction administration, which is the architect being out on site, observing the construction, commenting if something has been built that deviates from the plans that he prepared. But Justice Tingle was right on that issue too. What he did is he did his calculation of the fee. The total fee was $582,000. He subtracted $404,000 that was paid. So that brings you, I'm just giving you rough figures. That's about 178. And then he said, but wait, RFA didn't do the construction administration. They didn't do these services. They weren't out on site. So I'm deducting that 10% from the total. So he deducted $58,000, and that brought him to $119,000 before interest. So I think it was a very rational analysis performed by Justice Tingle in terms of how he got to the number. And the facts are all laid out in our brief, but the contract that we're talking about, just as a reminder, was executed in July of 2011. Justice Tingle found that the breach was in December of 2015. We are now coming up on the 10-year mark of the breach of contract that Justice Tingle determined was made by Carrollton. There is $350,000 set aside in an escrow account to resolve the fee that is due. At some point, RFA needs the justice. And again, I return to my point that the project was built, and to that extent, both sides deserve credit for not letting this whole thing go south. A project was built. And it was decided that we'll let this judge, we could have gone to a jury, we'll let this judge make a decision on the merits of the case, on his review of the facts, which again is a clearly erroneous standard, on his view of the law, and contracted interpretation is for the court to decide, which he did. He did not grant us Chapter 93A relief, which we sought. He did not, he backed out the construction administration costs, as I mentioned. He did not grant us $38,000 in additional services. So he made tough decisions. I read the decision multiple times before I came here, and I found all of the logic to be right in line with his job.
Can I ask you, what do you think the phrase total cost means in 5.1.1?
I think total cost means the total cost of the project when you're done. When you're done. And
how could that be implemented if there are, for lack of a better term, progress payments being made all along in accordance with the schedule in 11.2?
Because, Your Honor,
how can you determine a percentage of the total cost in order to make payments as the architect proceeds through its various stages?
Well, you make the payments based on an estimate, which they had early on. They had a $7.2 million estimate, which ended up being the exact same number as the bids that they eventually got. And to answer your question, though, how does this make sense? Typically, all of the services can be completed except for CA, and the project can be done before that final 10% is due.
If total cost is total cost of the project itself, then the final, even if the architect is not doing construction administration, then the final payment to the architect can't be known until the project is done.
But Your Honor, that's why the words estimated cost are in the contract.
I'm just trying to get your definition of what total cost means.
Yep. But that's why I'm saying if it was total cost, they would have put a period after those two words. Instead, it says total cost or estimated cost. And that's what this judge made a rational decision to go with in terms of evaluating how to factor a damages award. And ultimately, the decision was $119,000 in architectural fees, plus interest, plus attorney's fees.
I don't want to use up my fellow panelists' time, but I'm still not quite understanding what your definition of total cost is and how it would be rational.
Your Honor, it's rational if the project is done. Okay, you have a total cost for the project. But at the time of this trial...
So do you agree that the final payment to the architect can't be known until the project is done, even if the architect hasn't been involved in construction or contract administration?
No, I do not agree with that, Your Honor. Because what you have and what they did early on in this project is you have an estimated project cost of $7.2 million, upon which that other 90% is drawn off in terms of how much the payments are due.
Okay, but once the owner signs a contract to get the facility built, then absent change orders and things of that nature, we know what the total cost of the project is going to be, don't we?
No, because for the exact reason you just said, because of change orders, changes in scope, problems that develop at the site, you do not know the total cost, which is why they have the words "or estimated cost" in the contract.
So if that's true, then how could we ever use total cost? Because a change order is always a possibility.
No, you can use total cost if there's a different circumstance where the design is done and the project is built and the parties don't wait as they did here almost 10 years to build the project. So this was an extreme circumstance where at the time, again, the contract was 2011, Your Honor. We tried this case in 2023 and the project still wasn't done. So,
but even if things go very smoothly through, I don't see how under your definition of total cost, it could ever be used, because there's always the possibility of change orders.
It certainly couldn't be used in this case, Your Honor.
Well,
and that's why Judge Tingle went
is,
with estimated cost.
But we have to look at what the parties meant when they entered into this contract, now not how things actually played out with the unanticipated delays. At the time this prime contract was signed, I suppose everybody hoped that everything would go smoothly and the project would be built quickly.
Right, Your Honor, but just as I believe Justice Massing said, when you reach a point where you do not have an agreement on an essential contract term, you can file a lawsuit, you can put the issue in front of the judge or a trier of fact, and you can let them decide it. That's what the parties agreed to do here. Justice Tingle wrote a careful decision based on the facts and the law, and we request that that decision be affirmed.
I just want to ask one question. So you very helpfully in your brief, you list all of the bids. And so why did Justice Tingle pick TriStar as opposed to Dantex?
Because, well, he based it on, and he talks about it in his decision, he based it on Mr. Friedenfeld's testimony, where he explained in detail why he concluded those other bids were not responsible or qualified bids. And some of the factors that he weighed is, and you can see it in the bid, which I have here, but some of them, there's line items for specific work where they didn't even put a number in. So, in other words, they're giving you a bid, but they're zeroing out certain categories. Where TriStar...
Did Judge Tingle then say, I'm not going to enforce the responsible bid language, but then he chose a responsible bid?
No, the words that he used was the total cost. His words were a reasonable... I just want to give you his exact verbiage. He used the words lowest responsible bid in his decision. And that's what he was authorized to do as the fact finder in this case. Someone had to make this decision because The parties couldn't agree themselves on the issue. So at the end of the day, you need a fact finder, and he was the fact finder.
Okay, thank you both. I mean, was very helpful, and the case is submitted.
Thank you very much.
Okay, so we have one more case for today, and it's going to be in a hybrid format. So we're going to step off the bench for a couple of minutes while they get the attorney from Chicago on the line here, and we'll be right back as soon as that's ready.